I just, this is
Jim Vincent, yes.
Yeah, I just have one question. Are you saying that if there's a criminal charge, then LEOBoR cannot be, the administrative part of it has to be suspended, or it has to wait till that criminal charge is settled? Are we saying that you can't do both at the same time? Is that what's happening?
So, sorry. What I would say is that what was clear from the responses we heard from the chiefs in question, which solicited their input as it relates to criminal charges being brought and, quote unquote, I would say frustrating the process of LEOBoR moving forward, is that they said that it does take, since it does take judgment, it does slow down that process. And does delay the administration of discipline. However, the chiefs the importance of allowing proceedings to play out, the investigation to play out before moving forward, and that will become clear as those responses will speak for themselves when we send out the survey results by municipality.
Okay.
Any further questions for Jake? Yes, Tony.
I just want to thank Jake for taking the time to put this in perspective and bringing it to our attention. So I think it's very helpful.
Okay, thank you. Thank you. Chief, yes, Attorney, yes, General.
Look, Senator, thank you. I just wanted to address Mr. Vincent's point. You know, Jim, the reason the criminal process goes first is the stakes are higher there, of course. The standard is higher, but the stakes are also higher. You know, it's a potential criminal charge with all of the consequences that a criminal charge brings versus firing or gradated discipline. The reason those two things, and I believe, and I think every prosecutor in the country would tell you the same thing, I certainly felt this way as United States Attorney, is that you don't want multiple statements or investigations going on at the time. That's really a recipe for disaster. So you do your criminal investigation. When it's over, you can turn all of that over, aside from a grand jury investigation, although even there are a mechanism to turn that information over for administrative discipline. But it is unwise for two investigations to be going on at the same time. And that's true in the criminal space too. Certainly the U.S. Attorney's Office and the Attorney General's Office would never do two separate investigations of the same thing at the same time. That would be a very unwise practice. And so when the offices work together on criminal matters, we do them jointly. It's the same principle.
Thank you. My other comment is, and I had technical difficulties, but I would support Kia Bryant's comment there. You said that, I think, Jake, that 5 people went before LEOBoR and they were found guilty in all cases, with 2 being reduced from what the department how department suggested. Well, I would say that if the 2-day suspension is in place, then that's what they got was a paid vacation, a 6-month paid vacation. That's what happened to them. The people that were found guilty, they got a 6 months paid vacation in essence. So she's right.
If not, if there's no further comments or questions, we're going to turn it over to Chief Clements at this time.
I have some questions. I had my hand up. This is Michael.
Okay, Mike. I'm sorry. I can't see your picture, but go ahead, Michael. I'm sorry.
Yeah, just a couple of questions. Jake, thank you for the presentation. It's as with most of the presentations, it was very fact dense, and I was trying to take notes and listen. And there are a couple of questions I have. One, it's not clear to me, going back to your first chart or your first table. You said that row B was the number of discipline cases which did not result in a hearing. I don't know if that means that's the number of cases in which LEOBoR was not invoked, or simply that there wasn't a hearing. Can you clarify what that means?
So I actually think that your question is derivative of some differences in interpretation that some chiefs had. I think the most accurate way to look at that, because I think it would be unfair to characterize all of those charges of discipline as ones that could have progressed to LEOBoR. but did not. I actually think it's probably quite the opposite, and it may become clear when you review the individual charges themselves. For example, a local law enforcement agency reported 19 violations of discipline, 19 disciplines were handed out in a year, and none of those could have progressed to a hearing. They were written reprimands. However, they did fill out that next box as having not progressed to a hearing panel. And on the flip side of that, there were agencies that just left it blank based upon the fact that it could not have by right progressed to a hearing panel. So really, in some ways, it's unfair to treat them all the same. However, I did feel it was important to aggregate just because the question was asked. So I don't have the chart. Hold on one second.
And Jake, and that point you and I had spoken that I can address that as well. But go ahead.
If I just may finish real quick. For example, Mike, Mr. LEOBoR, like row B in 2015 was 161. That does not mean that all 161 of those instances of discipline could have progressed to LEOBoR, but did not. That's not saying the opposite either, which is that they couldn't have. But that may become clear when you review the individual surveys. And there were instances of discipline being issued that was well beyond the 2 days that was summarily accepted by the officer and did not progress to LEOBoR either. For example, there was a 15-day suspension, which by right the officer theoretically could have appealed to a panel. However, it did not. It was in a year where there were no hearing panels that adjudicated discipline. So, yeah.
No, thank you, and I think that just sort of underscores that the need for a deeper dive, because it's really confusing and
Right.
But I assume that also answers one of my other questions, which is why you had mentioned early in the presentation that you would explain why B through H does not add up to A. But I think that you've kind of explained that by saying that some of the disciplines that are included in the number in row A would not actually have allowed for the invocation of LEOBoR in any instance, right?
Correct. For example, a verbal reprimand, which a department documented, could not arise to that. However, they did provide it to us. And on the flip side of that, I'm sure there are also departments who maybe document those things in a different way, or if they document them at all, and maybe some of those kind of instances of discipline were underreported. I do think it's important to note that the number of hearing panels, based upon follow-up conversations with ranking law enforcement officers, is a fair and accurate representation of the number of times it's progressed to that point. But certainly, Mr. LEOBoR, I think you raise an important point, which is further reporting maybe should be done to understand how many instances of discipline could have progressed but do not, as well as how much discipline is handed out that doesn't arise to that, but maybe is repeated discipline maybe to the same officer. But that's just one thing I read. That's all.
Yeah, absolutely. Because the key thing that I think we need to know, or at least I would want to know, is in what percentage of cases in which an officer could have invoked LEOBoR did he or she choose not to. That, I think, is where the rubber meets the road, but I can't tell that from these numbers. It could be 100% of the cases, but I don't know.
I mean, I'll certainly review all of the individual surveys based upon what was provided to me as far as suspensions and things like that, where by right the officer would have been able to go to a panel and chose not to. I can certainly do that. I mean, but upon your review, I'm sure the idea of uniform, standardized process in place for reporting this misconduct is statewide, or a statewide standard rather, may be helpful.
Okay, thank you.